A very good afternoon to all of you. Surprisingly, you're all absent from the classroom, but I have not actually told you that we are not going to have a physical or face-to-face lecture today. But I'm even starting it just 5 or 2 meters away from your classroom. The classroom is completely empty. So I shared with my colleague, Mr. Daniel Buell, and I decided that let me set up a Zoom schedule if we'll be able to get you to come online. So thank God that as many of you as possible are here. So of course 51, that's not all of you, but at least we can still do some work and hope that we're able to record the session and make it available to those who through no fault of theirs are absent from this session. So just a quick recap. So far we've been discussing terms of contract, and we made the point that another way of referring to terms of contract is what we call like the content of the contract. That is the duties, the obligations. We have made the point before that by terms of contract, also known as the content of contract, thank God the Wi-Fi is back. The university network, it keeps coming and going off, but thank God. Yeah, so we've understood so far what terms of contract mean, and we have looked at how to identify or recognize the terms. In terms of express terms, what the parties themselves agree on. We've looked at where it is reduced into writing, the parole evidence for that and its exceptions. We've also discussed where it is by word of mouth, is oral contract. Now, how we use the objective test to try and determine what the parties agreed upon. Then we move on to discuss the relative importance of terms. Relative importance of terms. In other words, are terms same importance or some are more important than others? So that is where I think we were the last time, having already discussed implied terms. So I think the last time we said that traditionally, I think we've even gone beyond this, and then we put this on the recording on the YouTube for you. But we quickly and get out of here and continue with the exemption clause today. So with respect to categorization of terms, we said that our interest lies in understanding the basic question, whether terms, contracts are of the same status or some are more important than others. And we answered that question in the affirmative, that yes, some terms are more important than others. And for that reason, when they are breached or when they are broken, they generate different consequences and different remedies are available to the innocent parties. So we made the point that traditionally, terms are divided into condition and warranty. That is the traditional categorization of terms, condition or warranty. And we made the point that not too long ago, just 50 years or so ago, a hybrid term or intermediate term known as a nominate term was also recognized by the court. So making terms now, either conditional warrant or in limited cases, nominate or hybrid term, as the case may be. So we move on to take them one after the other. And we explain condition to be a term of major importance as it goes to the very root or the very foundation of the contract. And for that matter, where there is a breach of that term, the innocent party is entitled to repudiate the contract. In other words, treat the contract as having come to an end. And not only that, he'll be able to bring an action, that is sue, recover damages or compensation for breach of contract. And of course, should the defaulting party maybe bring an aspect of the contract to be enforced against this innocent party, he can set up the breach of that condition as a defense to any suit which the other party may want to bring for specific performance of some contract. So what is important, remember, is that a condition is a term of paramount importance. That is major importance. And why is this so? Because the contract depends upon that. So that if it is not true, if it is not there, if it is not carried out, it affects continuation of the contract. It affects the essence of the contract. And that is why a breach of it is considered as being a good ground, a good reason to repudiate the contract. In other words, to terminate the contract, treat the contract as having been discharged, as having come to an end. Yeah, so that is a condition. And we have also stated that a breach of it will enable the innocent party to not only sue, to treat the contract as having come to an end, but also sue to recover compensation, as it were. And then there's a traditional case of Posad against Pierce and Pond, decided in 1876, where there was a contract for employment of an actress. She was supposed to play a very important role, or the leading role, in an opera. That is a concert performance. I mean, those days, that was a major thing. And she fell ill 5 days before the first performance. And her illness, according to the facts, were serious. And you could not be sure regarding when it going to come to an end for her to recover fully. For that matter, she was not able to take part in the performance during the first week. Of course, it was not just going to be 1 week, it was going to be for a long period, about, I think, 3 months or so. And because she couldn't take part in the first week of performance, the management, those who were in charge of the production, decided to sign up a substitute to take her role, and accordingly proceeded to terminate the contract which they had with this particular person who had fallen sick. And later on, this person sued them for having terminated the contract. And the question which came up for determination was as whether the requirement that she takes up the rule right from the very start was a term of major importance or not. The court was of the view that yes, it was something of major importance, and for that matter, her inability to take part was a ground which could justify the producers going for another person. Yeah, so that was what the court said, that it was a condition, and if it is broken, it repudiates or it brings about termination of the contract. Now, a question which may come up is this. So, how do we know whether a term is a condition? Of course, we know what the condition is, but how does it become a condition? Is it the parties that will say that it is a condition, or it is the court? Well, in the course of our discussion, or what you ought to have read based upon my earlier direction, ultimately, it depends upon the intention of the parties. And the intention of the parties is to be gathered in the contract, except that where the parties have put a false label on a particular term, calling the condition, that per se will not be conclusive of the matter. And of course, you might have come across the famous words in the case of Street and Manford, that you cannot call a table a dog and expect that everybody will call the table a dog, as it were. So let's keep that in mind. So if you look at the Sale of Goods Act of 1962, certain terms have been implied terms have been designated as conditions. So once they've been designated as condition, then that is how it is. So that is one thing that we should keep in mind. So let's look at the flip side, or the contrast. We also have the warranties, and warranties, on the other hand, are terms of relatively lesser importance, or if you like, they are subsidiary statements of facts or promises. And because they're of lesser importance, in the event of their breach, the innocent party cannot treat the contract as having come to an end. The innocent party will have to continue to observe the contract, except that because there has been a breach, he will be entitled to bring a suit to recover damages. And last semester, when we were discussing damages for breach of contract, you came across the principle that it is the policy of the common law that whenever there has been a breach of a contract, the innocent party is entitled to damages, even if no particular loss or injury could be established following the breach of the contract. All that matters is that you can show that someone was supposed to do something and that was not carried out to the letter, and that is a breach. And warranty provide a good illustration for that. And that is why it is the law that where a warranty is breached, the innocent party cannot repudiate the contract, but can maintain an action for recovery of damages. If it will be what we call like a nominal damages, that is just a token or symbolic, as it were. Jessica Bay, do you want to speak? I notice you have unmuted yourself. Okay. Yeah, so a good case to illustrate warranties. Just as we saw Pusite against Spears in relation to condition, is a case of Bettany and Jai. Bettany and Jai, very interesting case. And the facts are very similar to what we have seen. So here, the singer was engaged to sing for a whole season of the opera performance and was supposed to arrive 6 days in advance before the takeoff of the production to enable the singer to take part in rehearsals and all that. But he was late and arrived 3 days instead of 6 days in advance, meaning that he missed some of the rehearsals. And the management of the opera did not want him to continue. So eventually, when the matter came to court, question which had to be resolved was whether the provision or the clause in the contract that he arrives 6 days to partake in the rehearsal is a term of major importance or not. If it is, then clearly by not arriving within the stipulated time, he was in a clear breach of his contractual obligation. On the other hand, if it is not, despite the fact that there has been a breach, it will not lead to repudiation or termination of the contract. But the internet went off, so it's back again. So let's continue. It's just unfortunate, but you have to manage. Yeah, so the court held that the rehearsal clause was a subsidiary term. That is something of a lesser importance. And for that matter, the late arrival did not entitle the producers to terminate the contract. So effectively, the court was saying that it was a warranty, not a condition. And since it is a warranty, it did not warrant or did not call for termination of the contract. That is what mine. And I was making the point not long ago as to how can we tell whether a term is a condition or warranty if we examine the contract the parties have made. Can we just say that this is a condition or this is a warranty? Well, as I indicated not long ago, ultimately, it depends upon the intention of the parties. The intention of the parties. And the intention of the parties is to be gathered from the contract. And mind you, the intention of the parties is not coterminous with the label or the description which the parties have given to the term. In other words, the parties might have stated that a particular term is a condition. On the other hand, if we examine the entirety, the totality of the contracts, if the court can gather from the entire contract that the true intentions of the parties is that that particular term should be something of relatively lesser importance, then notwithstanding the fact that the parties have given the label condition, the court could ignore that and say that that particular term is a warranty and not condition. So it's not so much about the description the parties have, but more importantly, the intention of the parties. Yeah, so that is what we should keep in mind. And case for us to remember is the well-known case of the Schooler against Wickman machine tools, in which the court emphasized that it is the intention of the parties rather than the description which they have given, which is really important. I notice some of you have started making annotation on the screen. Yeah, so in the Schuler against the Wickman case, in the relevant contract, there was a condition. I mean, we put the condition in quote and unquote. That is the description the parties are giving to that particular provision of, and that was that a distributor was supposed to visit sales customers every week. And the question was whether the failure of the distributor to be able to visit sales customers every week could justify termination of the contract. Now, the courts came to the conclusion that the word condition, which the parties had ascribed to that particular clause, should not be taken in strict sense or in ordinary meaning as a condition as opposed to a warranty. Because in the relevant contract, there was a separate clause which indicated when and the contract could be terminated. So the court was saying that insofar as there was a separate clause or provision given circumstances and the manner in which one could terminate the contract, then the fact that a certain clause or provision had been described as a condition should not be considered as having the usual consequences of a breach of a condition attendant upon it. And the usual consequences are that a breach of condition will justify termination of the contract, but that was not to be. Sorry, the internet went off again, but we are back. Okay, so let's take note of that. And I would like you to also look at our own case of Social Security Bank Limited against CBAM Services, which also illustrates how our own courts have applied the meaning of condition that we discussed. And I asked you to read Mrs. Donna Hammond's book on terms, and if you look at chapter 143, there she provides the case, but the report is in the library, and I would urge that just as you are supposed to brief all cases, it is useful for you not to use the lazy approach of learning, but to use the factful approach by going to read the entire decision so that you get the better insight into the case. So in the Social Security Bank Limited, there was a contract between CBAM Services, that is the appellant, and SSB with respect to money transfers, what they call like the MoneyGram. And as part of the agreement between the parties, SSB reserved the right to determine the agreement. To determine means that to end the agreement by giving 3 months notice in writing to CBAM, where CBAM was in breach and SSB wanted to exercise its right of termination. It just had to serve a notice that, yes, we want to end the contract because we think that you have broken it. It was further agreed by parties that CBAM, in addition to whatever advertisement and promotion programs that Monogram embark on, it will be responsible for advertising and promotion. Now, this was, however, made subject to submission of all its advertising and promotional programs and materials for written approval prior to embarking on the program. So that was the arrangement. SSB, that is the bank, terminated the agreement, citing the ground that such prior written approval was not given. That is to say that before CBAM did promotion and advertising, it did not refer the material to SSB for use to, before it went public to advertise. So that was the basis for exercising its right to terminate the contract. So CBAM sued SSB for breach of contract, and CBAM was successful at the Court of First Instance, that is the High Court, got the judgment that yes, SSB was in breach of the contract. The decision was affirmed again by the Court of Appeal, and SSB appealed finally to the Supreme Court, and the Supreme Court affirmed the decision by dismissing the appeal. And the Supreme Court held, among others, that it is open to parties to a contract to expressly provide that either of them has an option to terminate the contract. And a breach of fundamental essential term is one of the grounds upon which the contract may be terminated. So in the circumstances of this particular case, the parties themselves had provided how the contract may be terminated. And the Supreme Court made the point that a breach of obligation in the contract will necessarily call for an election on the part of the innocent party to exercise its right of termination, but that must fit into one of the several options or situations permitted by law. And that is one, that it goes to the whole root of the contract and not merely part of it. In other words, particular clause broken is fundamental. It goes to the root. That is obviously that is a condition. And so that is what the Supreme Court is trying to say. Or that which makes further performance impossible. Of course, later on we'll be discussing what they call the discharge by frustration. So where the contract is frustrated, then you cannot perform it and you will be excused from further performance. But that is not what we are talking about presently. So presently we are talking about where the contract cannot be continued because one person has broken a term of major importance. Sorry, the internet is behaving on campus, but we are back. So let's continue. Yeah, so please read the case of a Social Security Bank against the CBAM services. Now let's move on to the more recent category, what we call the innominate term or intermediate term. Intermediate in the sense that it lies in between. It is neither condition nor warranty. or we say nominate as, meaning that it cannot be named, because nominate means that it can be named, but innominate, it cannot be named. So you cannot name it either as a condition or a warranty. Yeah, so because if you go to the Latin, nomen, nomen, nominate means that you can name it. So if it's innominate, it means that it cannot be named. And why can't it be named? It cannot be named because you cannot name it as a condition or a warranty, or look at it differently. Intermediate in the sense that it lies in between. It lies and this is the story goes back to 1962, when the well-known case of Hong Kong Fair Shipping Company Limited against Kawasaki Kazan Kajal Limited, a case very interesting name. Hong Kong Fair Shipping Company Limited versus Kawasaki Kazan Kajal Limited. As I said, decided in 1962. Let's look at what happened in that case, and then we'll use that to discuss the development of this new category of term we called innominate or intermediate term. Now, in the Hong Kong Fair case, the plaintiffs own a ship which they chartered to the defendants for a period of 24 months from the delivery of the ship at Liverpool in February 1957. So this was a charter party. So charter party is simply a contract under which a ship or a marine vessel or so is leased or is hired. So this was the deal. So the ship had been leased or given out for 24 months. When it was delivered, the engine room staff were not many, and it also appears that they were the internet on campus is making the class not very exciting, but let's see. Yeah, so as I said, under the charter party or the contract, the ship had been hired for 20 months, but the staff, those who were working in the engine room, were not very competent. And the ship also had a bit of very antiquated or very old parts and so on. Now, there was a term in the contract or the charter party that the ship which the plaintiffs were supposed to provide to the defendants was in every way fitted for ordinary cargo service. Every way fitted for ordinary cargo service. Or fitted in every way for ordinary cargo service. So this was the crucial term. So the contract stated that yes, the ship that you are providing is in every way fitted for ordinary cargo service. Now, after the ship had been delivered, it became unseaworthy, especially on her voyage or return from Osaka in Japan. It was delayed in the high seas for 5 weeks, owing to a breakdown of the engine. And again, when it got to Osaka itself, it spent 15 more weeks because it spent another 15 more weeks because because the staff were not very competent, as there was a delay in actually getting the broken down engine fixed. So eventually, those who hired the ship, that is the defendant, they decided to repudiate the contract. That is, to terminate the charter party, to treat the contract as having come to an end. And they are no longer under obligation to do whatever they are supposed to do under the contract. The owners of the ship, that is the plaintiffs, they sued the defendants for breach of contract. And they contended that the defendant had wrongfully exercised the right of repudiation, as what had happened did not call for termination or repudiation of the contract. Eventually, when the matter got to court, the High Court, which was the court of first instance for purposes of this particular case, presided over by Justice Salmond, agreed that yes, there had been a breach of contract, but the breach of the contract in this particular case did not entitle the defendant to repudiate the contract, to treat the contract as having come to an end. The court was not disputing the fact that there had been a breach of agreement. There had been a breach of agreement, but the fundamental question was whether the type of breach which had occurred was that which could be used to terminate or to repudiate the contract. So that was the crux of the matter. Eventually, when it got to the Court of Appeal, the Court of Appeal was not very excited to use the usual terminology. The Court of Appeal was not excited to use the usual terminology to analyze what had happened. If I say the usual terminology, that is to try and say whether what had been broken was a condition or a warranty. The court was reluctant to use that. And the English Court of Appeal, speaking through Lord Justice Diplock, who eventually became a law lord in the House of Lords, acknowledged that it was where you have certain contracts, it was not all the time that you could reduce it to whether a particular term can right away be described as a condition or a warranty. But you need to adopt what we call the wait and see approach. Wait and see approach in the sense that you wait for the particular obligation to be broken, or the particular term to be broken. And then when the breach has taken place, then what you do is to try and wait. So the court was saying that it's not all the time that you can just use the straightforward dichotomy of a term being a condition or being a warranty. But some other times, you will need to actually adopt the wait and see approach, so that when a breach has occurred, you would actually gauge or weigh the effects of the breach on the rest of the contract. If the effect of the breach is to substantially deprive the innocent party of the entire benefit which he ought to have had under the contract, then the court will say that the innocent party should be given remedies which are given for a breach of a condition. On the other hand, if the effects or the consequence of the breach does not substantially deprive the innocent party of the benefit he or she should have received under the contract, then the court will say that the innocent party should be given remedies which are given for a warranty. So pay attention. Then you said that the court is still using condition and warranty language. No. You see, with respect to condition, what will happen is that you look at the contract, you can just interpret it and say that this term is a condition or that term is a warranty. Even when, as a matter of fact, there has not been any incidence of a breach, if no breach has occurred, you can still construe or interpret the contract and say that this is a condition or that is a warranty. And for that matter, all the legal effects which follow with the breach of a condition will kick in, and same thing applies to a warranty. However, with respect to innominate term or intermediate term, what is happening is that you cannot just look at the contract and interpret it and say that this is this or that is that. Rather, as Lord Justice Diplock indicated, you need to wait, let someone actually breach it. When the person has broken or has breached it, you weigh the impact, you weigh the effects of the breach on the contract. If the effect of the breach is very serious in the sense that it's virtually empty or deprive the innocent party of the most important benefit that he is supposed to get under the contract, then you say that the innocent party should be allowed to exercise remedies, which are usually exercised for breach of a condition. On the other hand, if you weigh the effect of the breach and it's not that serious, you will simply say that the innocent party should be given remedies for breach of a warranty. Yeah, so we simply say that the Hong Kong Fair introduced what we call the wait and see approach in trying to determine the status of a term in a contract. So that is what we should keep in mind. But of course, the Hong Kong Fair case also introduced a bit of confusion, because the confusion introduced was this. Does it mean that we should forget about the a plural classification by just using a condition or a warranty, and simply say that in every situation let a breach occur, and then when a breach has occurred, then we measure the impact of the breach on the contract, then we determine whether we should allow remedies for breach of condition or remedies for breach of a warranty. So if you look at the cases like the Mihalas Angelos, the Mihalas Angelos is another case which involved a charter party relating to the hiring of a vessel. The vessel was called the Mihalas Angelos. And the Court of Appeal seemed to have reverted to the old approach, that is, whether you treat it as a condition or as a warranty. Yeah, so I would like you to look at the Mihalas Angelos. But we also have other line of authorities which seems to follow what we call the breach-based principle. That is the wait and see approach. The wait and see approach in the Hong Kong Fair, because that is a breach-based, that wait for a breach to occur, and then you weigh the effect of the breach on the right of the innocent party under the contract, and before you make a determination as to how it should be compensated or not. So two cases, you look at the Sihave against the Bremer Handelsgesellschaft, as well as the the Hansard note. The Hansard note is the name of the ship at the stake in that particular case. And if you look at the case, for example, the seller had sold a cargo of citrus pellets with a term in the contract that the shipment be made in good condition. So that was the term. The shipment should be made in good condition. And eventually, the buyer rejected the cargo on the basis that this term had been broken. The term that the shipment should be made in good condition had been broken. This breaks here and there is very worrying, but it's a university network. Usually when I do my Zoom from home, it's more smooth than this network, but let's manage and see what we can do. Yeah, so the defects which the buyer was relying upon was not serious in the assessment of the court. It was not serious, and for that matter, the court held that although the English Sale of Goods Act had classified some terms as conditions and warranties, it did not follow that all the terms had to be so classified. Accordingly, in the Mihalas Angelos, the court held that it could consider the effect of the breach. And since in the circumstances of this particular case, the effect of the breach was not serious, the buyer was not entitled to reject the goods. The buyer was not entitled to repudiate the contract. Yeah, so that is what the court was saying. And what is interesting is that if you look at the Mihalis Angelos, the court going to the extent of saying that despite the fact that the Sale of Goods Act might have classified certain term as a condition or warranty, that was not conclusive of the matter. And that is why I said I did not follow that all the terms had to be so classified. And that in some appropriate circumstances, you need to look at the actual breach which has occurred and what is the effect of the breach on the rights of the innocent party under the contract. And that is what would actually be the guide and not any, if you like, predetermined classification as it were. And that was why in a similar case after the Mihalis Angelos case of Redden Smith against Hansen Tangen, an oil tanker was described as Osaka number 354. In fact, it was Oshima number 004. That was otherwise exactly as specified. It was just the description which appeared different. Now, because the market for oil tankers had collapsed, the charterers sought to argue that the number was a condition which will enable so that when the number was supposed to have been Osaka number 354 instead of the Oshima number 004, they wanted to use that to repudiate the contract. But if you look at the content, what was actually contained in the ship and all that, it was the same thing which had been contracted. And the House of Lords rejected the argument and held that the statement was a nominate term, not a condition. And since the effect of the breach was trivial, it did not justify termination of the contract. So here, you see that the court is still using the breach-based principle or the wait and see approach. Wait and see, after a breach, you weigh the effect of the breach on the contract. And before you decide whether the innocent party should be given remedies for breach of a condition or remedies for a breach of a warranty. Yeah. So interestingly, in 1981, the court indicated its willingness to go back to the traditional approach in the sense of going back to the pre-Hong Kong Fair, because the pre-Hong Kong Fair was a traditional approach. That is, a term was either a condition or a warranty, and there was no in between. There was no middle way. So the courts wanted to go back to the pre-Hong Kong Fair, and some judges were the view that Lord Justice Diplock had unnecessarily introduced complexity into the law, following his idea, this nominate term in Hong Kong Fair. And so some thought that, well, on grounds of commercial necessity, let's go back to the old approach. So the term is either condition or warranty, and there's nothing like see the breach before we can classify its status and so on. And that was why in Bank Against Traders, Lord Wilberforce remarked, and I quote, "I do not doubt that in suitable cases, the court should not be reluctant if the intentions of the parties as shown by the contract so indicate to hold that an obligation has the force of a condition, and that indeed they should usually do so in the case of time clauses in mercantile contracts. To such cases, the gravity of the breach approach, Hong Kong Fair, will be unsuitable." So simply in Bank Against Traders, Lord Wilberforce was just trying to say that we should appreciate that there are some instances in which the Hong Kong Fair principle will be irrelevant or will not be very helpful. So that was all that I was trying to say. And I usually like Hong Kong Fair or around it as part of my examination question. So you not do yourself a lot of harm if you pay attention. And because all of you like Mickey Mouse, Mickey Mouse would like to say that we have ended this side of the discussion and we'll move on to another aspect. So let me open my next slide and then we go straight away to discuss what they call the exclusion clauses. So maybe let me restart the recording so that it can easily be uploaded.